So hello, everyone, and welcome to our panel discussion on algorithmic bias in collaboration with the Faculty of Law and the Oxford Internet Institute. This event is hosted by the Executive Committee of Oxford Law Black Alumni, which was established in 2020 with a mission to support and help build relationships between Black students and alumni of the Oxford Law faculty. We have a view of establishing a global professional network through hosting a number of events. And so on behalf of our committee, I'd like to thank you all for engaging with us. I also want to take a moment to introduce myself and the executive committee of the Oxford Law Black Alumni. My name is Valencia, and I'm serving as the deputy president this year. In attendance today, we also have Jasmine Backus, our director of development, and Samuel Bailey, our treasurer. I would also like to introduce our president, Sfiso Zumalo. And before we get started, I'd also like to introduce our panelists for today, Professor Jeremias Adams-Prassl and Professor Sandra Wachter. Professor Jeremias is a professor of law at the Oxford Law Faculty, a fellow of Magdalen College, a member of the World Economic Forum's Global Future Council, and the deputy director of the Institute of European and Comparative Law. His recent publications include his book, Humans as a Service, which was awarded the St. Petersburg Private Law Prize, in addition to other publications such as The Concept of the Employer, The Autonomy of Labor Law, and his numerous contributions to the EU Law and the Member States series, of which he is the founding editor. His research focuses on technology, innovation, policy, and the future of work in the European Union and beyond. Recently, he was funded by the European Research Council to engage in a 5-year interdisciplinary project exploring the rise of algorithms at work, in addition to being awarded the 2020 Leverhulme Prize. Professor Sandra Wachter is an associate professor and senior research fellow at the Oxford Internet Institute, the lead coordinator for the Governance of Emerging Technologies Research Program, and an affiliate of the Berkman Klein Center for Internet and Society at Harvard University, the World Economic Forum's Global Futures on Values, Ethics, and Innovation, the UK Police Ethics Guidance Group, the Bonavero Institute for Human Rights, and the Oxford Martin School, among others. Both she and her work have been prominently featured in several documentaries and in media outlets like the Financial Times, Wired, and Business Insider. At the Internet Institute, her current research focuses on profiling inferential analytics, explainable AI, algorithmic bias, diversity and fairness, as well as governmental surveillance, predictive policing, and human rights online. She also works on ethical auditing methods for AI to compare bias and discrimination, with an emphasis on non-discrimination law. So thank you to everyone for attending. Thank you to our panelists for speaking, and I'm now happy to pass it on to the rest of our committee to facilitate questions.
Yes, thank you. Thank you so much for the introduction. I'm gonna start sharing my screen. Hopefully everything works. Yes, can I? Yes, I see nods. Fantastic, excellent. Yes, thank you so much for giving me the opportunity to talk to you a little bit about my work. And one of the things that I'm currently looking at is how AI is disrupting equality law or non-discrimination law. And one of the reasons why I chose this topic is because I think it's really important that the law might actually not be good enough to guard against those novel risks. But why do we actually care about fairness and bias in the AI in general? Why is this such a big concern at the moment? Well, the answer is quite straightforward. The problem stems from the technology in itself and how it works. Most of AI and machine learning works in a way that it looks at the past and is trying to predict the future. So you're looking at past historical data, you're trying to find certain patterns in that data, and then you're trying to use those patterns to make future decisions. So for example, in the context of hiring, something that Jeremias will be talking about in just a second, what you would do is, let's say you want to hire a professor at Oxford, what you would do is you would look at successful candidates of the past. You would feed the algorithm with their grades and their reference letters and their purpose of statements, and task the algorithms to find similarities between all those professors that have been served at Oxford. And then once you have that profile, you will compare future candidates with that past candidate. And if they're similar, you will offer them the job. And this is true for hiring, this is true for educational decisions, this is true for decisions about health or insurance. This would all be fine if we were always happy with the way that we make decisions. But very often employment decisions, health decisions, insurance decisions are riddled with bias and discrimination because the data inherits that. And so again, bias and discrimination and prejudice is not something necessarily new. And you could say, well, let's just use non-discrimination law to solve that problem. And that is something that I have been thinking about for quite some time. And as I said, I don't necessarily think that the law is fit for those future purposes. For those who are not intimately familiar with non-discrimination law, just very quickly an explanation of how the structure works. You have prohibitions against direct discrimination. So that means you treating somebody less favorably based on a protected attribute that they possess. So I'm not giving you the job or the loan because of your ethnicity, your sex, your gender. Or you have forms of indirect discrimination. So this is when a neutral provision criterion or practice is applied to everybody equally. And it just so happens that it disadvantages certain people more than others. So if you, for example, had a height requirement, when you're hiring people, you're only going to hire very tall people taller than 2 meters, you will know that this will have an indirect negative effect on at least women. So this makes a lot of sense in a human setting, but it's very different when algorithms hit the stage and the way that they make decisions. The first has to do with the need to feel injustice in the complaint-based system, and the other one has to do with how to prove your case in court. So non-discrimination law is based on a complaint-based system, which makes a lot of sense. What happens, you are in a work environment, for example, you're being harassed or somebody is promoted over your head. What happens is you bring a complaint, right? Because you feel the unfairness and the injustice. The issue with algorithms is that they discriminate behind your back without you actually being aware. And this has already happened in practice. So a very famous example is something that ProPublica shed light on a couple of years back, something that is still going on, where it was clear that Facebook is inferring protected attributes behind their backs of their users. So they were able to infer sexual orientation, ethnicity, gender, ability, and use that information to let advertisers exclude them from seeing certain things on the internet. So it would mean that, for example, people of color wouldn't see job advertisements, wouldn't see advertisements for housing or for financial services. But a complaint-based system breaks down if you don't know that you have been discriminated against. And this is a very big issue when algorithms are being deployed in various sectors. The second reason why non-discrimination law is not good enough anymore has to do with how you can prove your case in court. As I said, indirect discrimination, right, is the idea that something that isn't on the face problematic disadvantages certain people. With the height requirement, it was really clear to you that this could disadvantage women. How did you do that? Well, you used your intuition to do that. And this is what courts are usually doing. They use their intuition to judge those cases. So if there are, for example, bans of headscarves in the workplace, which happens, you would immediately know that this neutral rule could be in conflict with freedom of religion. Algorithms, on the other side, they use very untraditional data sources where disconnect is not immediately clear. So if an algorithm is, for example, using your shopping behavior, the things you look that you watch on Netflix, or what media you consume, it's going to be much, much harder to prove a connection. Are those things correlated with protected attributes? Are they correlated enough? And how would you actually prove that in court? So those two major problems that we face are that you might not know that you have been discriminated against. And even if you do know, you might not have the evidence to prove it in court. So question is, what do we do about this? Again, just very quickly, because this is the work that I've been doing, and I'm very happy to talk about it in more detail afterwards. But the answer is it's very, very hard to have one solution to find to solve that problem. But one thing is definitely clear. We need to test. That's the only way how we can mitigate this. And I wrote a paper with two of my colleagues that is called Why Fairness Cannot Be Automated, where we try to figure out whether there could be some sort of bias fairness test that would surface this unfairness where intuition might not be good enough anymore, and a test that also complies with what non-discrimination law has in mind when it's being applied. So when we did this with a test that we have developed that is called conditional demographic disparity. Again, I'm not going to go into detail, but the best way just to think about this is like a treasure map that shows you where dangers are and something that sends out an alarm when the algorithm is doing something that might be problematic. So if you're making a hiring decision, our test would tell you, oh, did you know that you're not giving job offers to any women? Was that on purpose? And that you can, interject and potentially remedy the situation. We're very lucky because the tests and the things that we have done on non-discrimination law are currently shaping legislation. So as you know, the European Union has decided to move forward with a framework, and we are now in the position that the European Commission has confirmed that some of the things that we have brought forward will be shaping the new drafts that are going to be coming forward very soon. So hopefully some of the things will be taken care of in future legislation. Industry has also picked up on the things that we have been doing. For example, Amazon is now offering the bias test that we have developed to their own customers. And again, this is just one way of tackling this problem. There is much more that needs to be done. But I think we really, really need to think about this, because I don't think there's a possibility where AI bias is not a problem. But if we can stick our heads together, I think we can come up with creative solution and save the law, because at the moment it's very teethless. But yeah, this is just some of the work that I have been doing, and I'm very happy to discuss this in the Q&A. Thank you.
Thank you so much, Sandra. Jeremias, if you're ready, we'd love to get some opening remarks from you as well.
Thank you. I'm just going to load my slides.
No worries.
Brilliant. Thank you so much to all of you for organizing this, and to all of you for joining us. And thank you also for Sandra for so perfectly setting the scene in terms of the challenges that we want to think about. As has been mentioned in the introduction, I'm currently working on a larger project about regulating artificial intelligence in the context of work, funded both by the European Research Council and the Leverhulme Trust. And this comes out of sort of past work I've done on the gig economy. So I've always been really interested in complexity, and how complexity, both legal and technical and economic, can be used to hide responsibility for when things go wrong. And over the last couple of years, one area in which I particularly explored this was the rise of the gig economy. Platforms like Uber or Deliveroo or Foodora on the continent that essentially promised for a long time to sort of revolutionize the world of work. And whilst lots of people, when we think about sort of discussions about artificial intelligence and the future of work, think very much about these sort of recurrent ideas of, the robots coming for our jobs and all of us losing our jobs and being unemployed. Well, actually, in reality, what started to happen much more frequently was that it wasn't workers' jobs that were increasingly being automated. When you look at a platform like Amazon or Uber, there's online platforms, it's actually traditional management tasks that we're increasingly seeing being automated. And it's really interesting that the gig economy was sort of very much a laboratory, or sort of at the forefront of a lot of these developments, where everything that a manager would have traditionally done, from interviewing workers and hiring them through to managing them, assigning shifts, assigning tasks, setting pay, all the way through to firing them, to terminating the employment relationship. Increasingly, what we saw in the gig economy is that all of these functions were starting to be automated. And whilst the great story was that actually that allowed us to overcome a lot of traditional problems in the labor market, sort of combat information asymmetries between customers and workers, combat information asymmetries between employers, engagers, and workers, the reality was that the kind of rating systems being deployed for purposes of algorithmic management actually turned out to be very deeply flawed. And actually, some of the early studies we see of bias and discrimination in the gig economy very much linked to the fact that even subconscious biases, once sort of amplified and layered on top of each other through multiple ratings, through the sort of interplay of different feedback mechanisms within apps and platform systems, very quickly had extremely discriminatory aspects, and ended up excluding workers from actually being able to work, ended up punishing workers of different minority groups by assigning them worse jobs, lower paid jobs, more arduous and more difficult jobs. And so it's really in that gig economy context that I first sort of started to become really interested in this important role of what happens when we're being managed by algorithms. What we have seen in the years since is that technologies first deployed in the context of the gig economy have quickly and increasingly come to workplaces across the socioeconomic spectrum. And even 2 years ago, when I sort of started first having discussions about this with various people, were saying, well, aren't these all edge cases? Isn't it quite niche? You know, I work at Oxford University. I still have to sign in to my lunch in college on a paper slip. Well, actually, the COVID-19 pandemic, I think, has led to an explosive growth of these artificial intelligence management systems. And indeed, today, I think it no longer matters whether you work in an Amazon warehouse or as an Uber driver, or whether you work in a professional service firm, in a law firm, in an institution, even like Oxford University. We're seeing all these traditional tasks automated. Indeed, also, whilst a lot of the debate at the moment is sort of centered around particular applications, particular companies offering, say, a dedicated hiring product or offering a dedicated work allocation system, the other thing increasingly to watch out is how a lot of these technologies of monitoring, of surveying, of collecting information, but then also using that to control workers is increasingly embedded into a lot of systems we use. And again, you need to look no further than Teams and MS 365, which of course all of us here at Oxford are very familiar with. And you see some of the offers that are built in, some of the capabilities that are built in, right? It's under the label of Delve Organization Analytics. MS Teams offers to do things like analyzing employee behavior at the individual level, looking at interactions, looking at email contexts, looking at mentions. It also then allows cross-organization comparisons. So the data is shared back with Microsoft and compared with workers in lots of different places. And remember, the various problems of algorithmic bias that Sandra has already been talking about are now deeply, fundamentally baked into the systems that manage us and that shape our day-to-day work. Now, you might be thinking, well, it's maybe not a bad idea if, you know, Christine can keep a tab on the various members of the law faculty. And, you know, as an associate dean, she needs to make sure to check that Jeremias is actually doing his job. Why should I care about this? Well, you'll find that just as creepy a set of systems is available in Teams to monitor students. I'm not saying that we use these systems, but certainly the systems are available, right? Things like you can see how many % of your students work at which part in time. It also offers you, this is a particularly weird one I find, so you to track how your students engage with class material and each other. You can check what they did within Teams throughout the day. For example, just before an online class, you can check who read the articles sent them as prep work. Now, personally, I probably don't want to do this because the result will probably be quite depressing, to be honest with you. But nonetheless, the notion that essentially every interaction we now have, or at least every interaction we have through these online systems, is in various ways monitored, analyzed, and then also to some extent the analysis is turned into prescriptions for actions, for various management actions. Now, I should say that, you know, there are some pockets, some niche pockets where you could say possibly there are some benefits to using these systems, particularly say in a health and safety context, for example, when used responsibly in terms of designing the workplaces more properly. But I think overwhelmingly what we're seeing at the moment is a vast amount of both material and immaterial harms. Now, in terms of material harms, I'm thinking about the sort of excessive strains and stresses that you have in terms of both mental and physical health, from sort of overworking, from getting automated emails in the evening saying, you know, Jeremias, you said 3 days ago you were going to write this reference. You still haven't written the reference. Why don't you, you know, get on with it? Through to the sort of material harms we see from stresses and strains from workers in warehouses, for example, being sort of continuously pushed on by an automated system to work faster, to work harder. And amongst the immaterial harms we have, discrimination is by far the most salient and most important one for precisely the various reasons that Sandra has already told us about. So whether it was Amazon famously scrapping a recruitment tool, again, the way Sandra explained earlier, this pattern spotting that goes on, and then this replication of existing patterns of bias in data. Well, that's exactly what happened when Amazon tried to automate its engineering recruitment, for example. Algorithm very quickly learned to punish various features that were clearly showing that women were the applicants, and Amazon in that own story. It's a very convenient story. We never quite got to the bottom of it, but nonetheless, they claim at least that the algorithm has now been scrapped. And the same is true in things like using facial analysis screening when it comes to hiring algorithms. Or also, there's a really interesting lawsuit going on at the moment in London, where a group of Uber drivers represented by the IWGB union are suing Uber for using facial recognition systems that are also deeply flawed and deeply biased, and accusing drivers of fraud and deactivating drivers when the facial recognition system didn't recognize their faces. So lots of immaterial harms we see here, particularly when it comes to discrimination. So what's the regulatory challenge? How can we think about this as lawyers? I think, as Sandra's already said, it's both a question of looking at existing legal frameworks, but then also how we can adapt them more broadly. At the core of my sort of legal technical interest is what I call the control accountability paradox. And it runs like something along the following lines. Historically, what we have is that the more control an individual or an entity exercises over individual workers, the more likely she's to be assigned responsibility in law for the exercise of that control. And whilst we see lots of historic legal attempts to sort of break up this control accountability paradox, whether it's using contract law by inserting clauses saying you agree to be self-employed, or whether it's using corporate law to include a complex structure of entities to say, well, actually, maybe it's this entity or that entity that, you know, controls you at any one time. As long as that evasion is using legal tricks, at least in principle, I think we also have legal answers to that. So when you use a contract where I just sign up and I'm an independent contractor, well, we have doctrines like primacy of fact or sham contracting in English law to get around it. When somebody uses, clever corporate structuring, again, well, at least in principle, I have doctrines like piercing the corporate veil or other forms of, for example, tortious ascription of responsibility to get around these complex corporate attempts at diffusing liability. What I'm worried about with the increased exercise of managerial functions through automated decision-making systems, in particular automated decision-making systems that include various machine learning and artificial intelligence techniques, is that whilst on the one hand, you can exercise a hitherto unimaginable degree of control, on the other, you might be seeing a real diffusion of responsibility across different actors, across different systems. And the problem, I think, from a regulatory perspective, is that evasion of responsibility is no longer inherent in the technology itself. So it's no longer inherent in the legal structures, but actually inherent in the technology itself. And that, I think, is at the core of how we have to rethink a lot of existing norms. The one example I've got for you from the specific employment context is a recently published proposal for a directive on improving working conditions in platform work. And that is actually the first legal instrument that specifically tries to grapple with sectoral regulation of artificial intelligence in the world of work. And it's got specific provisions, both in terms of information consultation provisions, but also things like access provisions for worker representatives, for trade unions. And it'll be really interesting to see the extent to which that measure will, well, first of all, make it through Parliament, but then also actually have a real impact in reshaping the way we think about AI at work. That's my quick introduction. Thank you very much again. I'm really looking forward to our questions.
Thank you so much, Jeremias, for that. And thank you again, Sandra, for your comments as well. We're now going to transition to the Q&A portion of our session. So first, we have a couple of questions from the OLBA organization that we'll ask to the panelists, and then we're going to leave some time, about 15 minutes, for everyone in the chat. So our first question is for you, Sandra. So a lot of people, when they're looking at the benefits of AI, they think about the benefits for the judicial system. We know that it can increase efficiency, improve access to justice, and help with less subjectivity. However, we also know AI may come with biases. Could you explain to us how algorithms actually become biased?
Yes, that's a great question, and I'm happy you used criminal justice as an example, because it's definitely one of the areas where a lot of people have worries about. Yes, you're absolutely right. There is a benefit to it in the sense that it's going to be cheaper, it's going to be more efficient, it's going to be more coherent. That's not a question. But that's not all I want from a justice system. I also want it to be just and fair. And the problem is an algorithm cannot be just and fair unless it learned how to be just and fair. And the problem is the data that it's learning from is all but just and fair. So just a couple of statistics here, right? Just let's think about the whole process of the judicial system. Let's think about if there's an equal distribution of what people get stopped and searched. It's more likely that you're going to be stopped and searched that you're a Black person 8 times higher than when you're a white person. It's much, much more likely that you're going to be charged when you're a Black person and a white person. It's much more likely that you're going to stand in trial, and it's much more likely that you are going to get a higher sentence than a white person. Right? This is not because the criminal activity is different between white and Black people. It's because the justice system is inherently biased. So the problem is algorithms don't know that. They only have those numbers. They see the differences of what people get charged and get sentenced, and that's exactly what the algorithm is learning. So they will assume that Black people are more likely to reoffend, even though that's not the case. So you end up in a situation where an algorithm is telling you, or where data is telling you the reality, but not the truth. And that's the big, big difference. And this is why many people say there are certain areas where we shouldn't be using algorithms because the data is inherently flawed. And the criminal justice system is actually one of the areas where people say we shouldn't be using that because the data is really, really bad. So yes, definitely an upside in terms of making the system more efficient, but a major downside in terms of making it more just, because it's just going to scale up and the injustices that are already there in a less obvious and more subtle way.
Thank you for that, Sandra. And just going on that same kind of line of fair and just, we also wanted to discuss if we do utilize AI in the judicial system, and we expect for the bench when they're deciding cases to decide it based on those particular facts that are before them. So to what extent, if we do utilize AI in the judicial system, is it actually decided the case based on those particular facts before it, in comparison to looking at the facts of those cases before and how those disputes were actually decided? And Jeremias, you can take this one.
Thank you. Well, I think to some extent, as I've been explaining, it's a bit of both, right? So in terms of, when I train a model, then I'm very much looking at the historical data. So it's very much about working out how to best fit a system that fits those patterns. Whereas then in actually applying it to each individual case, when I sort of am in the classification, then it's much more actually trying to see where relative to the pattern spotted in the existing data, my new data point, as it were, sits. And then on that basis, I have the recommendation or the decision. I think the real problem we've got here is that because it's about spotting patterns, a lot of machine learning essentially ends up punishing outliers. And that is one of the other sort of more fundamental reasons why we've got such problems with bias and discrimination. That the more you are removed from the sort of average representation in a data set, the more likely you are going to be penalized by this system. And you can imagine, particularly when then comes to the question of intersectionality, it rapidly gets worse and worse by multiple levels of degrees. So I think that the real problem here is that the bias and the discrimination we see in a lot of automated systems is not just random, but it's actually extremely systematic. So people like Meredith Whittaker have been dealing with this when sort of thinking about counterfactual questions of, well, should we worry about biased recruitment system when we know that human recruiters are just as biased? And one of her responses is to say, well, they might be, but at least there's some randomness to their bias, whereas the bias in a machine learning automated system is so systematic, so consistent, that actually once you are an outlier, you might really, really struggle.
Thank you so much for that answer, Jeremias. We've got another question here. So what are the best ways to fix algorithmic bias? Is the data itself, which that already contains the prejudices, Or does it mean that we actually need to teach the system how to apply the data in context? Sandra, if you want to maybe take a stab at that one.
Yes, I think the unfortunate truth is that there is not a one-fits-all solution, so it has to be tackled on various angles at the same time. There is a lot of stuff that you can do in terms of trying to fix the technology. The bias tests that I have mentioned are a way of figuring out what the algorithm is doing. There is a way of trying to fix the technology in terms of making it more accurate. So face recognition software that is less accurate on women and people of color, you can have a more diverse data set and train the algorithm to be more accurate on a diverse set of people, right? So that's the tech side of it. But this doesn't take away from the social bias, because just because you have an accurate facial recognition software, it doesn't mean you change the minds of the people that are going to be deploying that software in reality. So you still haven't gotten around to fixing the bias in the heads of a judge or a police officer or a person that is deciding if you should get a loan or if you should get employment or if you should get insurance, right? So the only way to really get unbiased data is to debias society and collect that data. And in order to do that, you actually have to do a lot of things. As I said, you need to change the minds of people who are making very important decisions. And you have to start very early on, because we are all being shaped by our environments. And very often we already as children have an idea of what the world looks like and what it's supposed to look like that doesn't necessarily reflect the best way of what a world could look like. And then there are legislators that need to do something. As I said, they need to fix the technology, the law that is currently not really working. And we definitely need to have technologists and industry to take up a more responsible role, because they cannot just pretend that those systems are not exacerbating biases. So in a way, everybody has to do something in order to mitigate that problem.
Perfect. Thank you so much, Sandra. So hypothetically, and I'm going to throw this question to you, Jeremias, is that if we do get successful in terms of approaching all those different segments that Sandra just kind of spoke to, don't we still have a downfall on the AI side? Because in deciding cases, a lot of what is actually necessary from the bench is those interpretive skills, it's those legal standards that are being applied in this specific case, it's those human elements as well. So can that kind of segment also be learned by AI when we're implementing it?
Thank you. That's a really good question. I think, again, there's not sort of a one-size-fits-all answer, right? I mean, I think there's some areas of law where actually you can automate a lot of judicial decision-making relatively straightforwardly, right? And this is sort of, think parking tickets, or sort of in very straightforward cases where actually the facts are pretty binary, it's very easy to establish. And actually, also you wouldn't have to worry too much about occasionally getting it wrong. Whereas there are other areas where, someone's freedom is at stake, or someone's very serious economic interests or personal interests are at stake, where even if you get to a very high degree of potential accuracy, we might still not want to actually automate those decisions. So about a year and a half ago, together with my wife, who's an economist in the Oxford Economics Department, we published an article in the Oxford Journal of Legal Studies where we tried to look at administrative law, and particular sort of emerging doctrine called systemic review, to start thinking about how we might want to choose when potentially to allow automation in the justice system and when not. And really what Abby and I do in this paper is that we look at this doctrine of systemic unfairness and link it to this notion of futility, the sort of potential impossibility of vindicating a meritorious claim. And throughout the case law, we can then identify two sort of large risk factors, right? So there's the risk of something going wrong, and then the cost of it going wrong. And I think when we look across the justice system, I think you have to look at both of those factors to work out when automation might be appropriate. So, if the cost of something going wrong is pretty low, like, an appeal against a parking ticket that costs £25, and the risk of it going wrong is pretty low, because actually that is something where, automated systems are very good at dealing with it, then I'd have fairly little concerns about actually going quite far down the automation route. On the other hand, if the risk of it going wrong, the risk of futility in our technical terms, is very high, for example, because someone's liberty is at stake or very significant economic interests at stake, and the chances of it going wrong, the risk of it going wrong is also very high. For example, because we know of all the biases in various sort of criminal justice automated or assisted augmented decision-making systems, then that's an absolute red flag, and under no circumstances must you ever deploy automated systems in those contexts. But we thought about it as having that sort of matrix, and really to allow you to evaluate different scenarios is one way in which, in a structured way but very responsive to particular settings, you can respond to that. And I can put the link to that paper in the chat if I manage to work out how to do it, if anyone is interested in looking at that further.
So we have one more question that we're going to open up to both panelists, and then we are going to turn the video off, and we're going to start reading some of the audience questions. So our very last question is actually for both of you. So given all the struggles we've discussed today, how much trust do we actually think the population is ever going to have in AI? You know, as we're thinking about these decision-making vital cases that we're going to be covering in the judicial system, will people ever be able to trust AI in letting that them make decisions?
Yes, I think that's a fantastic question. And I think what really needs to happen is not to get people to trust AI, but encourage them to have a healthy distrust when using the technology, as you should have with every type of technology, right? No technology is perfect. If you're Googling something and the results doesn't look right, you're gonna double check. If your GPS is gonna route you in an area where there's a ditch, you're not gonna follow. So what needs to happen is that just because something is very complex or is called intelligent, it doesn't necessarily mean that it's always gonna get it right. And so what needs to happen is that you just have a healthy trusting relationship. And especially in areas where we know there is bias, what needs to happen is that you don't think everything is okay unless proven differently, but you have to assume something is probably wrong unless somebody can prove the opposite. And that's what needs to happen with bias, because again, I don't really can think of a critical area where AI is being used where we don't run into bias problems. So you need to assume that there's probably something wrong, and then you need to put your thinking head on and trying to think how you can navigate through that. And the same has to do with understanding what the algorithm is actually doing. People often shy away from that because they think it is so complex, nobody can actually understand it. But that's also not always true, right? There is some things that you cannot explain, and there are some things that you don't want to explain because a trade secret is shrouding that particular case. And then we need to have a discussion on whether trade secrets are more important than transparency, or if it's actually the case and you cannot understand what's going on, which I don't believe, but if you cannot understand it, then it might mean that we shouldn't be using them in the first place, right? So it's more about trying to get self-confidence back and trying to assess, is the technology actually working for the purposes that I have in mind? Are they transparent and reliable enough? And unless you cannot show that it's actually working as it should, I should be applying a healthy distrusting situation.
I completely agree with Sandra, and sort of linked to that is very often just the amount of completely false claims that are being made by operators and vendors of these systems, right? So, or even the claims aren't false as such, just very specific and very limited approaches. And so again, understanding sometimes what's behind those claims is the first thing that's really important. So going back to good old teams, when you look at the productivity score that's assigned to each worker on the platform, essentially it turns out very quickly that productivity is a function of how much you engage with different Office products. Now, certainly in a lot of academic work, as you'll be aware of, sometimes we are most productive when our computer's switched off. Certainly when I'm not engaging with my emails, I'm not engaging with, Slack and everything else, but I'm just switching my computer off, sitting back, reading, thinking, staring out of the window, writing. None of these things would show up as productivity in an automated productivity score, right? So that's just one illustration of sort of what we measure doesn't necessarily then correlate to the things we actually want to know more about, or we would want to sort of have information about. The second thing in terms of trust, I think, is also an increasing role for legal regulation. I think it's really, really important that we don't just sort of fall into the trap of saying this is a technical problem, therefore there needs to be just technical solutions to it. And what I think about legal regulation, for example, there are certain context to certain deployments of AI systems, why would you say actually there's a good case for just banning them legally? Right? There are just certain practices that are so dangerous, so obviously proven not to work or be wrong. And I'm thinking, for example, about a lot of forms of sort of sentient analysis, right? This idea that you can work out, sort of my deep emotional states through various technical means. That to me is a very clear instance of something that actually I would say in the hiring context, we should just ban legally the use of these technologies. So I think a combination of sort of certain red lines, and then for other things also certain procedural ways. So again, in the employment context specifically, one really interesting case study you have is in German law. There's essentially a rule in German law that if a business wants to introduce new software that monitors workers or somehow conditions their workplace, management can't do it without discussions and approval from the workforce. Right? And that to me is a really interesting illustration where you can build trust and you can think about how to responsibly deploy systems, because workers get a veto right. So they can say, oh, there's a particularly creepy feature that monitors want to go to the bathroom. Definitely don't want to have that. But maybe there's a scheduling system that's actually fairer than what's going on at the moment, because at the moment it's the manager who gives the best slots to her friends, and the worst slots to the people she doesn't like. And maybe actually having a sort of more objective scheduling system could be a good idea. And so there's increasing evidence coming out of the sort of co-determination works council approach in Germany that's actually involving everyone, all the stakeholders in the rollout of these technologies, if you have built the necessary capacities for them to genuinely be able to engage, is actually a really good way of creating trust, in combination with some clear legal red lines to back up and ensure that there's this bargaining in the shadow of the law.
Thank you both. I mean, for those really, really, really good answers. I mean, I think it's one of those big concerns of us just kind of building trust in the system. And I know we're going to end the recording now, so we're going to try and jump in.